Hi, I'm Jesse Bifulco, host of the LifeCounsel podcast. Join me as I tell stories from my 25 years of experience as an estate planning and elder law attorney. I'll show you how you can keep more of your money and real estate and prevent family disruption using estate planning. Estate planning is more than just wills and trusts. It's about taking stock and contemplating important life decisions. It's about family and legacy too. As an estate planning lawyer, I help families avoid costly mistakes and conflicts. Welcome to LifeCounsel. Today's episode is entitled Special Needs, Special Planning. This is part 3 of the series about the difference between a will and a trust. Today we're going to look at ways to protect a vulnerable loved one. In the prior episodes, we talked about the reason people avoid probate. We also talked about when probate can be used to save your estate money. In today's story, Special Needs, Special Planning, we'll learn a great estate planning technique to protect your beneficiaries who you know will need some kind of help. In Cafe Dreams, I talked about something called a standby trust. That could be used to protect assets just in case when you die, your spouse is in a nursing home. But what if you already know of someone who will need help without you? What happens if your estate plan accidentally leaves your loved ones worse off rather than protected? Today I'll share a story about a family who thought they'd planned well, but discovered too late their child with special needs lost critical benefits because of a simple oversight. Stay with me as we uncover what went wrong, how it could have been avoided, and what you absolutely need to know to make sure it never happens to your family. Stick around to the end, and I'll share 2 little-known strategies you can use right away. One lets your disabled loved one spend money freely without losing their benefits, and the other provides affordable trust administration, even if your resources are limited. When I was a kid, the street I lived on had single-family houses on one side of the street, and on the other, right across from my house, was an apartment building. The residents of this strange dwelling seemed mysterious to me. 2 in particular stood out: an older woman and her daughter. They were different than the other parent-kid people on our block. For one thing, the daughter, even though her mom held her hand when they crossed the street, she was an adult. She smiled like a child, but it was clear that she was much older, and the mother was old enough to be a grandparent. They dressed in neat but modest clothes and walked and rode the bus, even to get their groceries. They came and went as regularly as clockwork for years. And then the mother started to look even older one day, kind of worn out. And then one day, they disappeared. I overheard some adults mention that the mom had died. I wondered what became of the daughter without her mom. I didn't know what Down syndrome was then, but I realize in hindsight that was likely how the daughter would be described. I grew up in New York City, in Staten Island, which had the infamous Willowbrook facility. My aunt and uncle lived on the outskirts of the Willowbrook campus. Between them and Willowbrook was a buffer of woods. My cousin told a story about how an inmate escaped and wandered into their backyard. He described it like it was an alien invasion. Geraldo Rivera became famous reporting on the abuses of Willowbrook. Willowbrook was where people like the little girl across the street, grown woman, were warehoused because their mom had died, when there was no one else to take care of them. The government programs that offer help to people with Down syndrome or developmental disabilities are far more humane than they used to be. Also, there are different levels of need. Today, there's a general policy to support them within the community. I once probated a will where one of the beneficiaries was disabled. The woman who died left 1/3 of her estate to her grandson. The year before she died, her grandson was in a motorcycle accident. It left him unable to work at the age of 25. The gift from his grandmother made him ineligible for benefits. His parents had finally found a group home for him, and he was settled there, much to their relief because he was somewhat independent and he needed to get out of the house. But the extra money left to him by his grandmother made him ineligible, and so he had to move out. Not long after that, he picked up a girlfriend or two who went through his money pretty quickly. But when the inheritance ran out, there was no spot for him at the group home anymore. In the instance of the woman across the street from my childhood home, perhaps she had a small pension or a little savings that could have benefited her daughter when she died. In the situation with the motorcycle accident, the grandmother had no idea that her beneficiary would be disabled when she died. Like with other estate planning, the key to getting the best result is planning. There are trusts specifically designed to hold assets for a disabled beneficiary. In the last episode, I talked about a standby trust. The standby trust is an if-then statement that you put into your estate plan. That is a trust put into your plan that can be used only if it's necessary. In that episode, we talked about a surviving spouse being disabled and therefore needing to have trust protections. But you can use that technique for any beneficiary. The standby trust works this way. It says, if when I die, my beneficiary is disabled, then hold their gift in a trust for their benefit. Or, if my beneficiary is receiving a government benefit, then spend the gift on them in a manner that does not make them ineligible for their benefits. These kinds of trusts are called supplemental needs trusts or special needs trusts. The key to remember is that the gift can be used without forfeiting benefits. So in the case of the boy injured in the motorcycle accident, his grandmother's inheritance could have been spread out over his lifetime, and he would not have been forced to move out of his group home. Also, he would not have been the victim of emotional blackmail because he would not have been able to access the money to give to his girlfriends. In the case of the the girl with Down syndrome, her money would have been managed professionally and used to benefit her. There are technical ins and outs to these trusts, but the important thing to know is that this planning exists because you don't know what you don't know, right? Whether you're incorporating a standby trust just in case, or if you know there's a vulnerable loved one in your life, then you need to sit down with an estate planning attorney versed in special needs planning. If you know you have a special needs beneficiary, you can establish the trust immediately. Without waiting until you die, you do this in case you or others wish to make gifts for your special needs beneficiary. There's a ready container, a ready receptacle to accept that gift. In other words, the trust exists already, it's set up, it's ready to be the beneficiary of a life insurance policy, or if drafted properly, it's ready to be the beneficiary of an IRA. You got it all set up and ready to go. And that trust would provide management without jeopardizing your beneficiary, his or her benefits. For example, a grandparent or other relative who wants to benefit the person with special needs, they can name that trust as her beneficiary or the beneficiary of a life insurance policy. A question frequently asked by my own planning clients is, what if there's something left over after my special needs beneficiary dies? For parents with multiple children, it's not unusual for a parent to leave an equal share of the estate for the benefit of a disabled son or daughter, and that gift might be substantial. If that disabled child is unlikely to have children of their own, the parent wants the remainder to pass to the other children, or maybe their grandchildren. The answer is yes, you can do that with a third-party supplemental needs trust. You can leave a share of your estate to a disabled beneficiary or a disabled child and specify that the remainder, if any, is passed to your other children or grandchildren. This can be done without forfeiting any necessary government benefits that the disabled child may be entitled to. What about a retirement account, an IRA? Can you leave retirement money to a trust for the benefit of a disabled child? The answer is yes. But you have to make sure the trust is drafted properly to comply with the IRS regulations. Trusts deal with management of assets, but there are less technical but sometimes more important pieces of information that should be shared with potential future caregivers to give, to know about this disabled beneficiary. You want them to know things that are important to their management, to help them. The reason is that the word disabled or special needs is not some kind of universal descriptor that has a specific list of character traits attached to it. If this applies to your family, you, of course, know that your child's unique and has his or her own personality. Calling them special needs doesn't really shed any light onto that, right? Also, the way their vulnerability attaches to their lives is unique. How do you communicate those other pieces of information? In other words, the basic structure of this trust is hold this money, manage it for my beneficiary, but there's more nuanced information that you want to communicate. You should create a document that spells out what you know about the needs and vulnerabilities of the special needs beneficiary. Also, like any other parent, you know your child best, and you know where they falter but could succeed. You might want to use the trust or the instructional document to encourage the development of their potential. If you weren't there to protect them, what would you tell someone interested in protecting your loved one? Is she too trusting? Is she stubborn? Does she like to walk near the edge of heights? Should she be pushed a little to get out more and meet other people? Avoid screen time. Like any other person, our vulnerable beneficiaries have their own peculiar character traits. Once the money part is set up correctly, then you should focus on the less tangible but equally important part of the plan. Here's a tip that you might use to help you develop your plan. Imagine that you yourself will be incapacitated at the level of the vulnerable loved one. Imagine you're going to be on that vulnerable level yourself, right? What would you need? Who would you need? I always tell people to try and build a network. If possible, think of at least 3 people who can be involved. They don't all need to have the same level of responsibility. Perhaps some are merely backups or have limited authority. And if you do not have anyone in mind, then discuss the possibility of a professional fiduciary, that is, a professional trustee, and or a care manager, perhaps with family member oversight. In building a plan for a vulnerable beneficiary, I find an engineering concept to be a useful metaphor. It's called redundancy of design. If you ever looked at a fighter jet, you'll notice that they have 4 wings when 2 are all that's needed. They have 4 engines and 2 tail wings. Why? Because if one gets shot off, the plane can still fly. It's similar with planning for a disabled beneficiary. You should consider having multiple people involved. You have a trustee to manage money. Should you also have a care manager to make a care plan? Should you have a trust protector to keep an eye on the trustee? Might there be a combination of professional and family members overseeing the trust money and the care? Back when I was a kid, there were not a lot of resources to make good plans for disabled beneficiaries. Fortunately, today there are. But to unlock these resources, you need to have an understanding that they exist, right? That's the point of this podcast. I just want you to know this stuff exists. I made a list of them, but I'd like to point out one specific resource that is extremely helpful. It was founded by really smart lawyers who had a personal connection to the topic. It's called the Special Needs Alliance. The website is listed below. There you can learn about special needs planning. It's a great resource, not just for people with special needs, for people planning for special needs beneficiaries, but also other lawyers interested in this field of practice. Remember, the LifeCounsel planning recommendation is to learn first. Learn what can be done to make yourself an enlightened consumer of legal services. Then vet a knowledgeable, experienced estate planning professional. The Special Needs Alliance website has a wealth of information as well as a way to find a special needs attorney. In our next podcast, did you ever wonder if a last will and testament had to be witnessed to be valid? What if the will is signed by you, but you do not have two witnesses? Is it still a valid will? Can a will that is not done by a lawyer, that doesn't have the formalities of execution, still be a valid will? In our next podcast, we'll answer that question in the story called What Happened to Claire's Inheritance, or The Holographic Will. It's got an animated story, so if you grew up with children's television like I did, it's going to feel nostalgic. But even though it's got a storybook feel, it's based on real life, and you'll learn a risk that faces widowed parents. How do we protect our kids from our own vulnerability at the end of life? Okay, so I mentioned at the beginning that if you listen to the end, I would reveal 2 important planning resources for your disabled beneficiaries. I said I'd tell you about a way that your disabled beneficiary could have cash to spend without losing his or her benefits. I also said I would tell you about a cost-effective way to have trust protection when the gift is relatively small and you don't want to incur big administrative costs. Or maybe a professional bank or trust company won't take the trust because it's below their minimum value. The ABLE account is the first one. That's ABLE. An ABLE account is kind of like an IRA for a disabled person. Money can be put into an ABLE account contributed by the disabled person or others. That money is there and available for their use and will not make them ineligible for government benefit. There are limits, and you have to use an ABLE designated bank account. But it's a good solution for an individual who maybe has a job or maybe a source of income that would put them over the top if it built up and they didn't spend it on things, or maybe they don't need to spend it right away, and so perhaps they need to save it. But perhaps it's too small an amount to make up for the lost benefit. So the second resource is called a pooled trust. Pooled like swimming pool, right? Most states have trusts that are made up of many smaller contributions for the benefit of many people. They pool together gifts in trust for the beneficiary to save money on administrative expenses. This is a way to get professional trust management when the gift is not large enough to hire a bank or a private trustee would cost too much. Thank you for listening, and I hope you enjoyed this episode. I'm Jesse Bifulco, host of the LifeCounsel podcast.